whether I had reference to the fact that if she kept her door open to the Oval Office, because there was always, the door to the hallway was always somewhat open, that she would always be able to hear something if anything went on that was, you know, too loud or whatever. I do not know what I meant. I'm just trying to reconcile the two statements as best I can without being sure.
There was at least one event where Mrs. Curry was definitely not even in the Oval Office area. Isn't that right? And I think you began to testify about that before. That was at the radio address?
I'm not sure of that, but in that case, there was certainly someone else there. I don't know.
Would you be testing Mrs. Curry's memory about whether someone else was there?
Well, I can say this. If I'm in the Oval Office, my belief is that there was someone else there, somewhere in the Oval Office complex. I've looked at the film. This night has become legendary now. You know, I've looked at the film we have. I've looked at my schedules. I've seen the people with the radio address. I do believe that I was alone with her from 15 to 20 minutes. I do believe that things happened then which were inappropriate. I don't remember whether Betty was there or not, but I can't imagine that since all this happened more or less continuously in that time period, there must have been someone who was working around the radio address who stayed around somewhere. That would be my guess. I don't know. I'm sorry I don't have records about who it would be, but I doubt very seriously if we were all alone in that Oval Office complex then.
Mr. President, if there is a semen stain belonging to you on a dress of Miss Lewinsky's, how would you explain that?
Well, Mr. Bittman, I don't, first of all, when you asked me for a blood test, I gave you one promptly. You came over here and got it. And we met that night, talked. So that's a question you already know the answer to, not if, but you know whether. And the main thing I can tell you is that doesn't affect the opening statement I made. The opening statement I made is that I had inappropriate, intimate contact. I take full responsibility for it. It wasn't her fault, it was mine. I do not believe that I violated the definition of sexual relations I was given by directly touching those parts of her body with the intent to arouse or gratify. And that's all I have to say. I think for the rest, you know what the evidence is, and it doesn't affect that statement.
Is it possible or impossible that your semen is on a dress belonging to Miss Lewinsky?
I have nothing to add to my statement about it, sir. You know what the facts are. There's no point in a hypothetical.
Don't you know what the facts are also, Mr. President?
I have nothing to add to my statement, sir.
Getting back to the conversation you had with Mrs. Curry on January 18th, you told her, if she testified that you told her, Monica came on to me and I never touched her. You did, in fact, of course, touch Miss Lewinsky, isn't that right? In a physically intimate way?
Now, I've testified about that. And that's one of those questions that I believe is answered by the statement that I made.
What was your purpose in making these statements to Mrs. Curry if they weren't for the purpose to try to suggest to her what she should say if ever asked?
Now, Mr. Bittman, I told you, the only thing I remember is when all this stuff blew up, I was trying to figure out what the facts were. I was trying to remember. I was trying to remember every time I had seen Miss Lewinsky. Once this thing was in Drudge and there was this argument about what it was or was not going to be in Newsweek, that was a clear signal to me, because Newsweek, frankly, had become almost a sponsoring media outlet for the Paula Jones case. and had a journalist who had been trying so far fruitlessly to find me in some sort of wrongdoing. And so I knew this was all going to come out. I did not know at the time, I will say again, I did not know that any of you were involved. I did not know that the Office of Independent Counsel was involved. And I was trying to get the facts and trying to think of the best defense we could construct in the face of what I thought was going to be a media onslaught. Once you became involved, I told Betty Curry not to worry, that she had been through a terrible time. She'd lost her brother, she'd lost her sister, her mother was in the hospital. I said, Betty, just don't worry about me, just relax, go in there and tell the truth, you'll be fine. Now that's all there was in this context.
Did the conversations that you had with Mrs. Curry, this conversation, did it refresh your recollection as to the events involving Ms. Lewinsky?
Well, as I remember, I do believe, in fairness, that you know, she may have felt some ambivalence about how to react, because there were some times when she seemed to say yes when I'm not sure she meant yes. There was a time it seems like there was one or two things where she said, well, remember this, that, or the other thing, which did reflect my recollection. So I would say a little yes and a little no.
Why was it then that 2 or 3 days later, given that the Washington Post article came out on January 21st, why would you have had another conversation with Betty Curry asking or making the exact same statements to her?
I don't know that I did. I remember having this one time. I don't know that I did. So.
If Mrs. Curry says you did, are you disputing that?
No, sir, I'm neither disputing.
Excuse me, is your representation, she testified that conversation was when?
I'm not making a representation as to what Mrs. Curry said. I'm asking the President if Mrs. Curry testified 2 or 3 days later, that 2 or 3 days after the conversation with the President on January 18th, that he called her into the Oval Office and went over the exact same statements that the President made to her on the 18th. Is that accurate? Is that a truthful statement by Mrs. Curry if she made it?
I do not remember how many times I talked to Betty Curry or when. I can't possibly remember that. I do remember when I first heard about this story breaking, trying to ascertain what the facts were, trying to ascertain what Betty's perception was. I remember that I was highly agitated, understandably, I think. And then I remember when I knew she was going to have to testify to the grand jury, and I felt terrible because she had been through this loss of her sister, this horrible accident at Christmas that killed her brother. Her mother was in the hospital. I was trying to make her understand that I didn't want her to be untruthful to the grand jury, and if her memory was different from mine, it was fine. Just go in there and tell them what she thought. So that's all I remember.
Mr. President, my name is Jackie Bennett. If I understand your current line of testimony, you're saying that your only interest in speaking with Ms. Curry in the days after your deposition was to refresh her own recollection?
Yes.
It was not to impart instructions on how she was to recall things in the future?
No, and certainly not under oath. That every day, Sir, Mr. Bennett, in the White House and in every other political organization, when you're subject to a barrage of press questions of any kind, you always try to make the best case you can consistent with the facts, that is, while being truthful. So I was concerned for a day or two there about this as a press story only. I had no idea you were involved in it for a couple of days. I think Betty Curry's testimony will be that I gave her explicit instructions or encouragement to just go in the grand jury and tell the truth. That's what I told her to do, and I thought she would.
Mr. President, when did you learn about the Drudge Report reporting allegations of you having a sexual relationship with someone at the White House?
I believe it was the morning of the 18th, I think.
What time of day, sir?
I have no idea.
Early morning hours?
Yeah, I think somebody called me and told me about it. Maybe Bruce, maybe someone else. I'm not sure. But I learned early in the 18th of the Drudge Report.
Very early morning hours, sir?
Now, my deposition was on the 17th. Is that right?
On Saturday the 17th, sir.
Yeah, I think it was when I got up Sunday morning, I think. Maybe it was late Saturday night. I don't remember for
Did you
sure.
call Betty Curry, sir, after the Drudge Report hit the wire?
I did.
Did you call her at home?
I did. Was that the night of the 17th?
Night of the 17th, early morning hours of the 18th?
Okay, yes. That's because, yes, I worked with Prime Minister Netanyahu that night until about midnight. Isn't that right?
Excuse me, I think the question is directed, Mr. Bennett, if you could help out by putting the day of the week, I think that would be helpful.
Saturday night, Sunday morning.
Yes. I called Betty Curry about as soon as I could after I finished with Prime Minister Netanyahu, and then the aftermath of that meeting, planning where we were going next in the Middle East peace process.
Can we take a 2-minute break, please?
May I ask one other question first?
Sure. I think where this is confused on dates, that's all.
That's what I didn't think it was the night of the 17th. Can we have a break and I could get straightened out?
Sure. May I ask one other question? This is a question I forgot to ask.
I don't want to get mixed up on these dates now. Go ahead.
This is, they wanted to know whether, they want us to clarify that the President's knowledge, your knowledge, Mr. President, as to the approach to our office this morning, that is, we were told that you would give a general statement about the nature of your relationship with Ms. Lewinsky, which you have done, and yet that you did not want to go into any of the details about the relationship, and that if we pressed on going into the details, that you would object to going into the details. And the grand jurors, before they wanted to vote on some other matters, they wanted to know whether you were aware of that we were told that.
Well, Mr. President, I told you that. This is not a fair question when you say you were told. Who told you?
Who told me what? The question?
You said the grand jury was told.
We have kept the grand jury informed, as we normally would, of the proceedings here.
Right. And I'm sorry, who are you representing told you or the grand jurors anything? Is that our conversation?
Yes. Our conversation. Yes. That was, in substance, related to the grand jurors.
And what's your question to me, Mr. Benton?
Whether you were aware of the facts that I just described.
Yes, sir. Let me say this. I knew that Mr. Kendall was going to talk with Judge Starr. What we wanted to do was to be as helpful as we could to you on the question of whether you felt I was being truthful. When I said I did not have sexual relations with Ms. Lewinsky, as defined in that definition 1 in my testimony. And I thought the best way to do that and still preserve some measure of privacy and dignity would be to invite all you and the grand jurors to ask, well, would you consider this, that, or the other thing covered by the definition? You asked me several questions there, and I did my best to answer whether I thought they were covered by the definition, and said if I thought they were covered, you could conclude from that my testimony is I did not do them. If things are not covered by the definition, and I don't believe they're covered, then I could not, then they shouldn't be within this discussion one way or the other. Now, I know this is somewhat unusual, but I would say to the grand jury, to put yourself in my position, this is not a typical grand jury testimony. I have to assume a report is going to Congress. And there's a videotape being made of this, allegedly because only one member of the grand jury is absent. This is highly unusual. And in addition to that, I have sustained a breathtaking number of leaks of grand jury proceedings. And so I think I am right to answer all the questions about perjury, but not to say things which will be forever in the historic annals of the United States because of this unprecedented videotape and may be leaked at any time. I just think it's a mistake. And so I'm doing my best to cooperate with the grand jury and still protect myself, my family, and my office.
Thank you.
Now, we've been observing earlier that the president appeared to be doing quite well and indeed helping himself substantially by his testimony, and we wondered why the zeal among the Republican ranks to have this come out the way it's coming out. But I must say I see two problems for him now in what's happened in the last half hour. The one is this problem about his conversation with Betty Curry the morning after he was sandbagged in the Paula Jones deposition. And he kept saying to her, I was never alone with her, right? And self-serving statements such as that. He is testifying now, he's telling this grand jury, he was trying to get information from Betty Curry so he could respond to press questions. But in fact, it was brought out here, he would know better than Betty Curry if he'd ever been alone with Monica Lewinsky.
Yeah, I think this could actually prove to be a more troublesome area even than the Lewinsky affidavit, for which at least he has an answer of sorts. This is one where when you listen to him, you can tell he's struggling. I think we saw sweat, perspiration for the first time. So we haven't seen the kind of dramatic demeanor, loss of temper, storming off that we thought, although we're still not finished. But certainly, this is the area where he seems to have had the most difficulty in the entire deposition.
Well, and I do see another problem with him, the so-called look, Ma, no hands defense, in which he did tell that jury flat out that he did not, basically, he did not touch her breast, he did not kiss her breast, he did not touch her genitalia.
But we knew that was there before we started.
Well, I know, but the point is, and he told him that, and that one is going to be...
I agree.
And I would say that Monica Lewinsky may have more credibility at this point in time on questions such as that than Bill Clinton.
If the whole thing hinges on whether people believe that he never touched her breast, which is really, in a simple way, what that comes down to, that's a real tough one. But we haven't learned that today. The one I think we may have learned is to see how difficult...
Directly asked about oral sex performed on you by Monica Lewinsky.
If the judge had required me to answer it, of course I would have answered it. And I would have answered it truthfully.
By the way, do you believe that the Jones litigants had the same understanding of sexual relations that you claim you have?
I don't know what their understanding was, sir. My belief is that they thought they'd get this whole thing in, and that they were going to, what they were trying to do is do just what they did with Gennifer Flowers. They wanted to find anything they could get from me or anyone else that was negative, and then they wanted to leak it to hurt me in the press, which they did, even though the judge ordered them not to. So I think their position, Mr. Bennett, you asked the question, their position was, we're going to cast the widest net we can and get as much embarrassing stuff as we can and then dump it out there and see if we can make him bleed. I think that's what they were trying to do.
Don't you think, sir, that they could have done more damage to you politically or in whatever context if they had understood the definition the same way you did and asked the question directly?
I don't know, sir. As I said, I didn't work with their lawyers in preparing this case. I knew the case was wrong. I knew what our evidence was. By the time of this deposition, they knew what their evidence was. Their whole strategy was, well, our lawsuit's not good, but maybe we can hurt him with the discovery. And, you know, they did some. But it didn't amount to much. And did I want, if I could, to avoid talking about Monica Lewinsky? Yes, I'd give anything in the world not to be here talking about it. I'd give anything in the world not to have to admit what I've had to admit today. But if you look at my answer in the Flowers deposition, at least you know I tried to carefully fit all my answers within the framework there, because otherwise there was no reason in the wide world for me to do anything other than make the statements I'd made about Gennifer Flowers since 1991, that I did not have a 12-year affair with her, and the following accusations she made are false. So that's all I can tell you. I can't prove anything.
But you did have a great deal of anxiety in the hours and days following the end of your deposition on the 17th. Isn't that fair to say?
Well, I had a little anxiety the next day, of course, because of the Drudge Report. And I had an anxiety after the deposition because it was more about Monica Lewinsky than it was about Paula Jones.
The specificity of the questions relating to Monica Lewinsky alarmed you. Isn't that fair to say?
Yes, and it bothered me, too, that I couldn't remember the answers. It bothered me that I couldn't, as Mr. Weisenberg pointed out, it bothered me that I couldn't remember all the answers. I did the best I could, and so I wanted to know what the deal was, sure.
Mr. President, to your knowledge, have you turned over, in response to the grand jury subpoenas, all gifts that Monica Lewinsky gave you?
To my knowledge, I have, sir. As you know, on occasion, Mr. Kendall has asked for your help in identifying those gifts. And I think there were a couple that we came across in our search that were not on the list you gave us that I remembered in the course of our search had been given to me, to Monica Lewinsky, and we gave them to you. So, to the best of my knowledge, we have given you everything we have.
Can you explain why on the very day that Monica Lewinsky testified in the grand jury on August 6th of this year, you wore a necktie that she had given you?
No, sir, I don't believe I did. What necktie was it?
The necktie you wore on August 6th, sir?
Well, I don't know that it was a necktie Monica Lewinsky gave me. Can you describe it to me?
Well, I don't want to take time at this point, but we will provide you with photographic evidence of that, Mr. President.
If you give me, I don't believe that's accurate, Mr. Bennett.
So let me ask.
But if you give it to me, and I look at it and I remember that she gave it to me, I'll be happy to produce it. I do not believe that's right.
Well, if you remember that she gave it to you, why haven't you produced it to the grand jury?
I don't remember that she gave it to me. That's why I asked you what the tie was. I have no earthly idea. I believe that that I did not wear a tie she gave me on August the 6th.
Can you tell us why Bayani Nelvis wore a tie that Monica Lewinsky had given you on the day he appeared in the grand jury?
I don't know that he did.
Have you given Bayani Nelvis any ties, sir?
Oh, yes, a lot of ties.
And so if he wore the tie that you gave him, that Monica Lewinsky had given you, that would not have been by design. Is that what you're telling us?
Oh, absolutely not. May I explain, Mr. Bennett? It won't take long. Every year since I've been president, I've gotten quite a large number of ties, as you might imagine. I have a couple of friends, one in Chicago and one in Florida, who give me a lot of ties. A lot of other people who send me ties all the time or give them to me when I see them. So I always have the growing number of ties in my closet. What I normally do if someone gives me a tie as a gift is I wear it a time or two. I may use it, but at the end of every year, and sometimes 2 times a year, sometimes more, I go through my tie closet and I think of all the things that I won't wear a lot or that I might give away, and I give them mostly to the men who work there. I give them to people like Glenn and Nelvis, who work in the kitchen back in the White House, or the gentlemen who are my stewards, or the butlers, or the people who run the elevators. And I give a lot of ties away a year. I bet excluding Christmas, I bet I give 30, 40, maybe more ties away a year. And then, of course, at Christmas a lot. So there would be nothing unusual if, in fact, Nelvis had a tie that originally had come into my tie closet from Monica Lewinsky. It wouldn't be unusual. It wouldn't be by design. And there are several other people of whom that is also true.
Mr. President, I'd like to move to a different area right now. I'd like to ask you some questions about Kathleen Willey. You met Kathleen Willey during your 1992 campaign, isn't that so?
Yes, sir, I did.
As a matter of fact, you first saw her at a rope line at the Richmond, Virginia airport on October 13, 1992. Is that not correct?
I don't believe that is correct.
When did you first meet her, sir?
Well, let me ask you this. When was the debate in Richmond?
I believe it was October 13, 1992, sir.
Well, I believe that I had met her, before then, because Governor Wilder, I believe that was his last year's governor. I think that's right. 92, 93. I believe that I met her in connection with her involvement with Governor Wilder. And I have the impression, it's kind of a vague number, but I have the impression that I'd met her once before, at least once before I came to that Richmond debate. Now, I'm not sure of that.
Well, at least if you had met her before.
But I am quite sure she was at the Richmond debate, and I did not meet her there. I'm quite sure of that.
Mr. President, you've seen television footage of you standing on a rope line with Donald Byer, Lieutenant Governor Donald Byer, asking Mr. Byer for the name of Kathleen Willey. You've seen that footage, haven't you?
I don't know that I've seen it, but I am aware that it exists.
All right. And you can see him, you can read his lips, he's saying the name Kathleen Willey in response to a question from you. Is that so?
That's what I've heard.
And as a matter of fact, you sent Nancy Hernreich, who was present on that day, to go get her telephone number, didn't you, sir?
I don't believe so.
You don't believe so?
Well, let me say this. If that is true, then I'm quite certain that I had met her before. I would never call someone out of the blue that I saw on a rope line and send Nancy Hernreich to get her number to do it.
Even if you were just learning her name for the first time?
That's correct. I'm not so sure that I didn't ask Don Byer, if he was on the rope line with me, who she was, because I thought I had seen her before, or I knew I'd seen her before, and I didn't remember her name. Now, I do that all the time, for men and women.
I'm sorry. Do you recall that you sent Nancy Hernreich to get her telephone number?
No, I don't.
All right. Do you recall having received her telephone number, calling her that night?
No, sir, I don't.
Do you recall inviting her to meet with you at your hotel that night?
No, sir, I do not.
Do you recall where you stayed in Richmond, Virginia during the debate you told us about?
Well, I stayed at some hotel there, I believe.
Actually, did you stay at the Williamsburg Inn, not in Richmond?
Yeah, that's right. We prepared in Williamsburg. That's correct. I believe we prepared in Williamsburg and then went to Richmond for the debate, and then I think we spent the night in Richmond, and the next day I think we had a rally before we left town. I believe that's right.
Do you know of any reason Kathleen Willey's telephone number would appear on your toll records from your room in Williamsburg?
No,
you didn't call her.
No, I'm not denying that I called her, sir. You asked me a specific question. I won't deny that I called her. I don't know whether I did or not.
Matter of fact, you called her twice that day, didn't you, sir?
I don't recall. I may well have done it, and I don't know why I did it.
Well, does it refresh your recollection that you called her and invited her to come to your room that night, sir?
I don't believe I did that, sir.
If Kathleen Willey has said that, she's mistaken or lying. Is that correct, Mr. President?
I do not believe I did that. That's correct.
But what is your best recollection of that conversation, those conversations?
I don't remember talking to her, but it seems to me that at some point, this is why I believe I'd met her before, too. But at some point, I had some actual person-to-person conversation with her about my sore throat and what she thought would be good for it or something like that. I have some vague memory of that. That's it.
Is this the chicken soup conversation, Mr. President?
Well, I don't know if I would come. Maybe that's what she said I should have. I don't remember. But I have no recollection, sir, of asking her to come to my room. I'm sorry, I don't. I won't deny calling her. I don't know if I did call her. I don't know if she tried to call me first. I don't know anything about that. I met her and Doug Wilder. I remember that she and her husband were active for Governor Wilder, and that's about all I remember, except that I had a conversation with her around the Richmond debate. I do remember talking to her there.
Mr. President, let's move ahead to the episode on November 29, 1993, in which Mrs. Willey met you in your office at the Oval. The subject matter of the 60 Minutes broadcast a few months ago. You recall that episode?
I certainly do.
Mr. President, in fact, on that day, you did make sexual advances on Kathleen Willey. Is that not correct?
That's false.
You did grab her breast, as she said.
I did not.
You did place your hand on her groin area, as she said.
No, I didn't.
and you placed her hand on your genitals, did you not?
Mr. Bennett, I didn't do any of that. And the questions you're asking, I think, betray the bias of this operation that has troubled me for a long time. You know what evidence was released after the 60 Minutes broadcast that I think pretty well shattered Kathleen Willey's credibility. You know what people down in Richmond said about her. You know what she said about other people that wasn't true. I don't know if you've made all this available to the grand jury or not. She was not telling the truth. She asked for the appointment with me. She asked for it repeatedly.
Did she make a sexual advance on you, Mr. President?
On that day, no, she did not. She was troubled.
On some other day?
I wouldn't call it a sexual advance. She was always very friendly, but I never took it seriously.
Mr. President, you mentioned the documents that were released and information that came out from people in Richmond, et cetera, after the 60 Minutes piece was broadcast. As a matter of fact, you were required under the court's rulings to produce those documents in response to document requests by the Jones litigants. Is that correct?
No, I believe the Jones litigants, the request for production of documents to me, ran the documents that were in my personal files and in my personal possession, and did not cover documents that were White House files. So I don't believe we were required to produce them. As a matter of fact, when that story first ran, sir, before 60 Minutes was back in July or so of '97, I was aware that we had some letters. I didn't dream Kathleen Willey. I didn't remember that she'd written as much as she had and called as much as she had and asked to see me as often as she had after this alleged incident. I didn't know the volume of contact that she had, which undermined the story she has told. But I knew there was some of it. And I made a decision that I did not want to release it voluntarily to her after the Newsweek ran the story, because her friend Julie Steele was in the story saying she, Kathleen Willey, asked her to lie. And because, frankly, her husband had committed suicide, she apparently was out of money. And I thought, who knows how anybody would react under that? So I didn't. But now when 60 Minutes came with the story and everybody blew it up, I thought we would release it. But I do not believe we were required to release White House documents to the Jones lawyers.
Mr. President, have you made a decision on whether to stay beyond the 4 hours we agreed to accept questions from the grand jury?
We have made an agreement, Mr. Bennett, to give you 4 hours. We're going to do that. By my watch, there are about 12 minutes left.
I guess that's no. Is that correct, Mr. Kendall?
Yes, that's correct.
May I ask you a question? Could I have a 2-minute break?
Sure.
We'll get to it. Thanks. I'm sorry to bother you, but I know we're getting to the end, but I need to.
Now, it does appear to me that the president is having increasing problems.
Yeah, and he does seem ill at ease in handling these questions, though you reminded me, I'd forgotten, there's so many things going on in this case, that the Willey documents they're referring to are the documents she allegedly wrote to him expressing fondness after the event of this.
Yeah, she wrote some letters that the White House, what happened was the Paula Jones lawyers had sent a kind of a blanket subpoena to him, and they said, turn over all documents that you have from Kathleen Willey. He had received these letters. We just heard him say that, well, they weren't in my custody, they were in the White House custody, and so I didn't turn them over.
Interesting, and I think it's interesting that the really tough things, the things that we were really focused on coming in here, the president did pretty well with. The Betty Curry conversations remain troublesome, and for some reason he seems rather uncomfortable with the Willey material, even though they seem to believe that the White House, that they have a substantive answer for it.
It's interesting to me, and I don't know what your experience has been, it seems to me that the grand jurors are personally very involved in this, and that the grand jurors appear to be taking it kind of hard and almost personally, I was about to say, the fact that he is refusing to answer some of these questions.
Grand jurors tend to be asking many of the tough questions, many of the questions that a juror would be thinking about if there were a trial. And also, it's unusual. I mean, let's go back to how unusual it is for a witness to be allowed to not only come in with his own definition, at least his own initial statement, but basically to refuse without legal grounds to answer questions. And I think that's frustrating the grand jurors who are undoubtedly being told by the prosecutors he has no legal basis for this.
Well, it's interesting to me that this now apparently is going to be the basis for any decision by either first the House Judiciary Committee as to whether or not to convene a formal inquiry, and second, whether or not for the entire House to approve some articles of impeachment. And I must say, having heard what I've heard, it seems to me that anything they might find would be considerably more narrow.
Oh, this is...
I think probably they're having a resumption now and will
Let's go
listen.
back.
Invoked executive privilege in response to questions that have been posed to them by the grand jury and in the grand jury. One of the grand jurors has posed the question, did you personally authorize the invocation of executive privilege?
If the answer is authorized, I think the answer to that would be yes. But I would like the grand jury to know something. In the cases where we raise the lawyer-client privilege or executive privilege, or where the Secret Service raised their privilege, and when I had nothing to do with that. I did not authorize it, approve it, or anything else. That was something they asked to be free to make their decision on by themselves. In none of those cases did I actually have any worry about what the people involved would say. The reason those privileges were advanced and litigated was that I believed that there was an honest difference between Judge Starr and the Office of Independent Counsel and Mr. Ruff, my counsel, and I about what the proper balance was in the constitutional framework. And I did not want to put the presidency at risk of being weakened as an institution without having those matters litigated. Now, we've lost some of those matters. Our people have testified, and the grand jury is free to conclude whether they believe that the testimony they gave was damaging to me, but I don't imagine it was, and I wasn't worried about it. It was an honest difference of constitutional principle between Judge Starr and the Office of Independent Counsel in the White House.
Mr. President, a couple of very brief questions given our time. The White House's outside counsel, Mr. Eggleston, withdrew the White House's appeal from Chief Judge Johnson's ruling that the invocation of executive privilege had to give way to the grand jury's right to the information. That ruling in connection with the testimony of Mr. Blumenthal and Mr. Lindsay. Were you informed of that fact that the appeal had been withdrawn?
I was informed of it, and as a matter of fact, I was consulted about it, and I strongly supported it. I didn't want to appeal it. It was... I have my main difference, Judge Starr, as you know, with you and with some of the court decisions, is on the extent to which members of the White House counsel staff, like Mr. Lindsay, should be able to counsel the president on matters that may seem like they're private, like the Jones case, but inevitably intrude on the daily work of the president. But I didn't really want to advance an executive privilege claim in this case beyond having it litigated so that we had not given up on principle this matter without having some judge rule on it. So
excuse me, and you're satisfied that you now have the benefit of that ruling, is that correct?
Well, yes, I just didn't want to, I didn't want to, yes, and I actually, I think, made the call, or at least I supported the call. I strongly felt we should not appeal your victory on the executive privilege issue.
Mr. President, among the many remaining questions of the grand jurors is one that they would like answered directly without relation to, without regard to inferences, which is the following. Did Monica Lewinsky perform oral sex on you? They would like a direct answer to that, yes or no.
Well, that's not the first time that question's been asked. But since I believe, and I think any person, reasonable person would believe, that that is not covered in the definition of sexual relations I was given, I'm not going to answer except to refer to my statement. I had intimate contact with her that was inappropriate. I do not believe any of the contacts I had with her violated the definition I was given. Therefore, I believe I did not do anything but testify truthfully on these matters.
We have a couple of photos of the tie that you wore.
And would you please give them to me?
Yes.
Now, this is this August 6th, is that correct?
1998, the day that Monica Lewinsky appeared at the grand jury. And my question to you on that is, were you sending some kind of a signal to her by wearing
No, sir.
one of the ties? Let me finish if you don't mind.
Sure, I'm sorry. I apologize.
Were you sending some kind of a signal to her by wearing a tie she had given you on the day that she appeared in front of the grand jury?
No, sir. I don't believe she gave me this tie. And if I was sending a signal, I'm about to send a terrible signal, and maybe you ought to invite her to talk again. I don't want to make light about this. I don't believe she gave me this tie. I don't remember giving me this tie. And I had absolutely no thought of this in my mind when I wore it. If she did, I don't remember it, and this is the very first I've ever heard of it.
Did you realize when you, can I just have for the record, what are the exhibit numbers?
Yeah, there should be pages 5 and 6.
All right. Mr. Bennett has some more questions.
Mr. President, we were talking about your responses to document requests in the Jones litigation, and I had just asked you about turning over the Kathleen Willey correspondence. You recall that?
Yes, sir, I do.
And if I understand your testimony, you did not believe that the request for documents compelled you to search for those documents in the White House?
Mr. Bennett, I want to answer this question in a way that is completely satisfactory to you and the grand jury without violating the lawyer-client privilege, which is still intact. It was my understanding that in the request for production of documents, that those requests ran against and operated against my personal files. Now, I have some personal files in the White House. And I'm sorry, in this case, I'm not my own lawyer, and I don't know how the distinction is made between, excuse me, files which are the personal files of the president and files which are White House files. But I do have a very clear memory that we were duty-bound to search and turn over evidence, or excuse me, documents that were in my personal file, but not in the White House files. And I believe that the letters to which you refer, Miss Willey's letters and Miss Willey's phone messages, were in the White House file, and therefore I was instructed at least that we had fully complied with the Jones lawyers' request, and that these documents were outside the request.
Mr. President, you're not contending that White House documents stored in the fashion these were stored, are beyond your care, custody, or control, are you?
Mr. Bennett, that may be a legal term of art that I don't have the capacity to answer. I can only tell you what I remember. I remember being told in no uncertain terms that if these were personal files of the president, we had to produce documents. If they were essentially White House files, we were not bound to do so. And so we didn't.
So you're saying somebody told you that you didn't have to produce White House documents?
That's it.
I question the witness that this question should not invade the sphere of the attorney-client privilege.
Yes.
Any conversations with counsel or privilege?
Let me say, maybe, Mr. Kendall, we need a break here. I'm trying to avoid invading the lawyer-client privilege. I can just tell you that I did the best I could to comply with this. And eventually we did make, of course, all of this public. And it was damaging to Miss Willey and her credibility. It was terribly damaging to her. And the first time she came out with this story, I didn't do it. I only did it when they went back on 60 Minutes and they made this big deal of it, and it turned out she had tried to sell this story and make all this money. And I must say, when I saw how many letters and phone calls and messages there were that totally undercut her account, I myself was surprised.
But you knew there were letters.
I did, sir.
And
I knew
the White
that
House is under your control, isn't it, Mr. President?
Well, Mr. Bennett, again, I'm not trying to be, some days I think it's under my control and some days I'm not so sure. But if you're asking me as a matter of law, I don't want to discuss that because that's, I mean, I'll be glad to discuss it, but I'm not the person who should make that decision. That decision should be made by someone who can give me appropriate advice, and I don't want to violate the lawyer-client privilege here.
Well, Mr. President, how are the letters from Kathleen Willey that surfaced after the 60 Minutes episode aired any different from the correspondence and other matters, tangible items, tangible things, of Monica Lewinsky?
Well, the items you asked for from Monica Lewinsky that I produced to you, you know, that there was a tie, a coffee cup, a number of other things I had. Then I told you there were some things that had been in my possession that I no longer had. I don't know if I did that. It was one book, I remember, that I left on vacation last summer.
The same documents that the Jones litigants had asked you
Yes,
for.
but at any rate, they were different. The gifts were in my personal possession, clearly.
In your office at the Oval?
Well, in the books, now that the presidential books were with my other books that belonged to me personally. They were in the Oval.
Where do you draw the line, sir, between personal and White House? You're talking about some documents that are in the Oval Office, and we don't see where you're drawing the line.
Well, Mr. Bennett, I don't think these were, I think the Lewinsky gifts were all non-documents, and you can... Just a moment. I'd like to finish answering the question, please, because this is a legitimate question, I think. There's somebody in the White House, Mr. Bennett, who can answer your question, and you could call them up and they could answer it under oath for you. There is some way of disaggregating what papers are personal to the president and what papers are part of the White House official archives of papers. And I don't know how the distinction is made. I just don't know.
Did you direct that personnel, Nancy Hernreich or anyone else, make a search for correspondence from Kathleen Willey and Monica Lewinsky when those documents were called for in the Jones litigation, sir? Did you direct that somebody on the White House staff look for those documents?
I don't believe that I was in charge of doing the document search, sir. So the strict answer to that question is that I didn't.
So you sat back and relied on this legalistic distinction between your personal, which you're in control of, and the White House, which, by the way, you're also in control of. Is that not correct?
I want to check the argumentative form of the question will allow the witness to answer it. We're now over time, even 30 seconds, so this will be it.
Mr. Bennett, I haven't said this all day long. A lawsuit that was dismissed for lack of legal merit, but that cost me a fortune and was designed to embarrass me. This independent counsel inquiry, which has gone on a very long time and cost a great deal of money, and about which serious questions have been raised, and a number of other things. And during this whole time, I have tried as best I could to keep my mind on the job the American people gave me. I did not make the legal judgment about how the documents were decided upon that should be given to the Jones lawyers and one that shouldn't. And I might add that Miss Willey would have been very happy that these papers were not turned over because they damaged her credibility so much, had they not ultimately been turned over after she made, I think, the grievous error of going on 60 Minutes and saying all those things that were not true. But I did not make the decision. It was not my job. This thing was being managed by other people. I was trying to do my job.
Mr. President, the grand jury, I'm notified, still has unanswered questions of you, and we appeal to you again to make yourself available to answer those questions.
Mr. Bennett, our agreement was for 4 hours. We've not counted the break time
And-
against that, and I think...
You know, Mr. Bennett, I wish I could do it. I wish the grand jurors had been allowed to come here today as we invited them to do. I wanted them down here. I wanted them to be able to see me directly. I wanted them to be able to ask these questions directly, but we made an agreement that was different, and I think I will go ahead and stick with the terms of it.
The invitation was made after there was political fallout over the deposition circumstances with the satellite transmission and the taping. Isn't that so?
I don't know about the tape, and Mr. Bennett, I understood that the prospect of the grand jurors coming down here was raised fairly early. I don't know. But anyway, I wish they could have. I respect the grand jury. I
Just
wish
for
they
the
could.
record, the invitation to the grand jury was contingent upon us not videotaping, and we had to videotape because we have an absent grand jury. Thank
Is
you.
that the only reason, Mr. Weisenberg, you have videotape?
Well, yeah. You want to answer that, Mr. Weisenberg?
Silly.
Thank you very much.
And so that is a termination of what by any measure is a historic bit of testimony, grand jury testimony by the President of the United States, which is being put on television, unscreened by the television networks and so forth. No question but that this is an historic matter, but there's some question as to whether or not what we have just seen is really quite of the character that we were led to believe in some news reports and some statements by politicians prior to the matter. Let me just introduce to you, Raymond Brown and I are joined here by 3 other people, by Nancy Grace, who of course is one of our own. She's one of our anchors. By Professor John Pavia. He is a professor of constitutional law at Quinnipiac School of Law, and he practices in Stamford, Connecticut. And Mickey Sherman. Mickey Sherman is with us a lot here on Court TV, and he practices law in Stamford, Connecticut. I want to, what do you think, Mickey, about we were told that we were going to see examples of the president's famous temper, and that there would be outbursts here. Now, maybe I'm just mild-mannered, but I didn't see anything that would qualify there. How did you read it?
I don't know, Fred, those must have been the outtakes that were edited out or something. For me, I was totally underwhelmed. I think from the hype, we expected to see a reenactment of the Humphrey Bogart character, Captain Queeg, from the Caine Mutiny. You know, the anger, the paranoia. That was a controlled witness, a controlling witness. I think President Clinton controlled the questioners, and he was absolutely a larger-than-life witness. Now, I'm not saying what he did is moral and wonderful. The man was wrong, but he admitted it to the American public, looking them straight into the eye. He gave them rational, not justifiable, but rational answers, and he did not come off in any way as though he was evading the questions, more so than anybody does when they're on the witness stand.
I want to go to Professor John Pavia, and first of all, did I misstate? You practice in Farmington, Connecticut.
Right.
Did I state that wrong?
Right, that's right.
Okay, we want to be sure that we
That's
get you right there. Now, what's your take on whether or not, just your sense of this? Do you think that this would be expected to be the premise of the House approving articles of impeachment?
Well, let me just say, if I could, respond to the first question you asked, which was, I thought he did very well also. I agree with Mickey. I was led to believe, I think, as like everyone else, that this was going to be a bombshell, but I thought he was a very controlled witness. I was impressed, quite frankly. In terms of your second question, he was candid about the sexual relations, at least to the point where he admitted an inappropriate sexual relationship, but did not go into details. As to your question, Fred, I do think that encouraging someone to lie and retrieving physical pieces of evidence that have been subpoenaed would constitute grounds for impeachment. And on those issues, he was very clear. He denied that when he spoke with Betty Curry, he did it with any intent to influence her testimony. He also reiterated that he didn't know that the Office of Independent Counsel was at that point involved. When I do depositions or whenever I was in the grand jury, if someone goes that far out of the way to keep reiterating a point that I didn't even ask about, I start to question a little bit. And so on that point, I do have some questions. But I do think he did well in terms of presentation, in terms of substance, the battle lines are clearly drawn. I think the White House is not afraid of the perjury. I think they're more afraid of the subornation and of the obstruction charges.
Well, on that point, I want to ask Nancy Grace. Nancy, we talked a little bit about the problem that he really seemed to have in answering on the question of perhaps trying to influence a witness or perhaps obstructing justice, why it was on the day after this testimony he seemed to be suggesting to Betty Curry, his secretary, that she go along with what he had testified to the day before. Now, as a lawyer, would you have difficulties in defending, or I'm sorry, as a prosecutor, making a perjury case based, or obstruction of justice, or witness tampering case based on that?
Yes, I would, Fred, and I think, as you'll recall, the president almost took a break, but he did not take a break, trying to determine the date specifically on which that conversation with Betty Curry occurred. He went on and on to emphasize in front of the grand jury that he told her repeatedly to tell the truth, to relax, and tell the truth, were his words. He said that his conversation with Betty Curry was more an effort for him to recap in his own mind, with her helping him, what had happened, what she was aware of, and basically it intimated to me what her testimony would be if she were ever called. But as far as subornation of perjury, I don't think that a prosecution will be made out. Fred, you asked me earlier to update you on anything that was occurring. Things have been released while we were talking. Now new photos are being released by the House of Representatives, photos of Clinton with Monica Lewinsky. These are photos we have not seen yet. There are going to be 2 photos. This is part of Ken Starr's case. Also, photos in Mr. Starr's case regarding gifts given by President Clinton to Monica Lewinsky. They include things such as a Radio City Music Hall throw blanket. Fred, I believe I was in Rockefeller Center that night that President Clinton was there. Traffic was stopped up for miles around. A Radio City Music Hall throw blanket, a handbag, a stuffed animal, a book. Just doesn't sound like the stuff a prosecution is made of.
But this is a different prosecution, Fred. I mean, this is a political prosecution in the House of Representatives first, and then in the Senate. So, you know, the standard is not beyond a reasonable doubt.
But if we look at this, if we look at the evidence we've seen today, in light of John's correct assessment that this is a political prosecution, if the thought was that the Starr report was a body blow and a shot to the head was coming today, if anything, the president moved ahead in his demeanor, and I thought he had pretty good substantive answers, whether or not you accept all of them as true. And probably, I hesitate to disagree with Nancy, especially about what's prosecutable, but I think the problem with Betty Curry is she's a friend, so anything she says that will hurt him will be construed as true. And it's the area where he seemed most uncomfortable and where his explanation is probably the biggest stretch. That may be his areas of greatest vulnerability, though it's hard to see him impeached on the basis of that.
You know, the thing John Pavia said there, as I understood him, was that he became suspicious. He says, as a prosecutor, when you hear someone deny something over and over and over again, kind of gratuitously, before a grand jury, you begin to wonder if maybe it's not a lie. And the president said over and over and over again, I did not ask her to lie. I did not ask anyone to lie. I tend to believe that because he is so smart, and I think he is a man who knows how to suggest to someone that they might fudge the truth a little bit without ever asking them.
So he's doing the same thing, though. He's parsing his words, though, Fred, saying, I didn't ask her to lie, and I'm not saying he did, but
that's what the crime
he's suggesting that he's doing the same thing that Bill Clinton has been alleged to always have done, which is he's very careful with his words, and today he's telling us, I didn't ask her to lie, but I do think the upshot can be that through his efforts, that's exactly what he wanted her to do. And when he's talking to Monica Lewinsky, and he's telling her that she can give an affidavit that's technically true, that can get her basically out of the Paula Jones case, I think he's basically asking her to do what he has always done, and that is to parse his words very carefully. But I think
we keep using the term parsing the words as though there's something wrong with it. Remember what he said, and if jurors or grand jurors or even congressmen believe this, it raises an interesting backdrop. He's saying he deliberately went into the deposition trying not to say anything that was untruthful, but not trying to help those who would leak material to others. If you keep that in mind, and therefore keep in mind that the mindset of the person was not to commit perjury, but to say as little as possible consistent with the oath, then that's a different perspective. And to the extent that the president did anything today, it was to kind of create the environment that's where my head was. Now, people cannot believe that, but if you believe it, it gives him a leg up.
Well, I want to ask Mickey Sherman here. Mickey, you're a defense lawyer. If you were defending a case, and let's assume this is in court rather than an impeachment, which is a little spongier, hard to get a handle on. Could you defend based on what you saw here?
Defend the president?
Yes.
Absolutely. And I think, as Ray just pointed out, he was also upfront about the fact that he said he was involved in a lawsuit that was bogus on the law and bogus on the facts. That's the president's words. And he wanted to be legal, but not particularly helpful. And, you know, there's nothing wrong with that. He's allowed to do that. Number one, he's an extremely bright man. He's also an attorney, for whatever that means. And he's on the witness stand for 4 hours. He's entitled to be artful or inartful as he may be. And the fact that he's not helping the other lawyers, the Jones lawyers, during that deposition, that's of no moment. He's not, as he points out, he's not expected to make their case for them.
Well, now, let me ask you this, though, Mickey, before we move back to John Pavia. In his grand jury testimony, where there does seem to be a square conflict, Monica Lewinsky says that he touched her in intimate places. He says no. Doesn't she have a little more credibility here than he does on such matters? And isn't that a tough spot?
Why'd you ask Mickey that particular question,
Is
Fred?
this the same Monica Lewinsky who gave a sworn affidavit that they didn't have a relationship?
Well,
I mean, don't forget, everyone has some baggage here. I personally don't believe the president there. I will tell you that. But by the same token, beyond a reasonable doubt, I don't know. We also have the witness against him, allegedly, Monica Lewinsky, has also already lied about it. And as the president points out, in kind of a backhanded sweep to her, I'm glad that she and her mother got those great deals with the, as he said, pointed out, sweeping immunity. It was his way of telling the grand jury, you know, these folks are rats. They bought a deal against me.
John Pavia, do you believe that there are an awful lot of ordinary people and even lawyers, as we've heard from Mickey Sherman, who are going to say, look, under the circumstances of these assignations, to believe that you never touched her in ways she says you did is a stretch?
Well, yeah, I do, but I also agree with Mickey in that from a purely legalistic standpoint, I don't blame the president, and I have no problems, very few problems, with him being very careful with his words. He's a very smart guy. He is an attorney. He's not there to help the Paula Jones attorneys. So that's why I said before, I don't think, and I've never felt, that their big concern is the perjury. I do think that they have problems with the subordination and obstruction. Remember that when Betty Curry comes before the House Judiciary, which I think she eventually will, she's going to be confronted with a lot of her own grand jury testimony. She'll also be confronted with her initial interviews with the FBI. And remember that during those interviews, according to the reports that we have, she was not very helpful to the president whatsoever. In fact, I think she was very damaging. Now, that testimony or those statements were not under oath. And when she finally gave her testimony on the very salient points of whether or not the president asked her to retrieve the gifts or whether that came from Monica Lewinsky, there was a lot of I don't remembers and I don't recalls. But I do think, like I've said many times before, and I think Nancy and I were on the show last night together, I do think this will come down to the credibility of the other witnesses before the House Judiciary Committee, and that's where the test is really going to be.
Now, Nancy Grace has been fielding some of the new information that's coming in from Washington based on documentary disclosures made today, and I believe you have some involving Monica Lewinsky.
Yes, even as we were talking, Fred Graham, information is pouring in through the wires here to Court TV. The House is releasing some of Monica Lewinsky's statements. In one, she referred to the president as her sexual soulmate, but that she realized he was ending her relationship and became somewhat bitter at that point. She describes the relationship herself as partial love and partial obsession with the president. This fits hand in glove with the president's testimony. We just observed that he knew once the relationship ended, she would feel the need to discuss the relationship. He did not think the relationship would remain a secret. He says he still describes her as a good girl with a good heart. She says, and this is released today by the House, that she became bitter and did not want the relationship to break off. At grand jury, she had a chart made out called Highlights of My Relationship with the President. And in that, she describes as part of the relationship nonverbal connection. In other words, eye contact with the president. In her mind, that was part of a relationship. The White House pizza nights became a big event for her, according to this chart. She also states, Fred, very interestingly, that he never asked her point blank to deny their relationship. She says she began to grow bitter in 97. Yes.
She backs him up on the statement that he repeated throughout his testimony.
But you don't have to show that he directly, I mean, technically under the law and under 1512, you don't have to show that he specifically said, look, I want you to lie. Just remember that.
Fred, I think the issue with Monica is interesting because you talked about the no hands part. The reason that's not real credible is not because Monica Lewinsky says it's otherwise. It's because it doesn't seem to comport with human experience and common sense.
Well, I think
Monica
that's what
Lewinsky
Mickey
is
Sherman
probably,
was suggesting.
Yeah, mincemeat.
Yeah.
Another issue, Fred, I thought you might want to know this. I just got a wire put in my hand where the House has released where Monica Lewinsky stated that the president described his concern about leaving messages on her answer machine. This was long before a Jones subpoena had occurred. He did not want his name or identity showing up on caller ID. She stated no sex, no relations conducted in the Oval Office, that the White House aides actually tried to keep her away from the president throughout this. And it was revealed today that one of the grand jurors actually chastised Miss Lewinsky for having a second affair with a married man. Don't know what became of that conversation in the grand jury, but that was released today.
You know, I'd like to step back here for a moment with all four members, all four of you, and get your sense of something that I've thought about throughout the last 4.5 hours as we've seen the president being questioned. And that's the broader issue of whether or not just the whole subject matter of all of this under our constitutional system, Ray Brown should rise to an impeachment proceeding.
Well, my view all along has been that this was a bad decision in terms of prosecutorial discretion to follow this down the road. Because given the time consumption and given the relatively minor nature of the underlying issues, it's important. If the president had lied about national security matters, if he lied about issues concerning fundamental issues of importance to the American people, then that should be something to look at. But this kind of thing, I think, doesn't, even if all the allegations are true, rise to the level of high crimes and misdemeanors.
Mickey Sherman?
Well, you know, you don't have to be rabidly pro-Clinton to come to the same conclusion that Ray did. I mean, about an hour ago, about 2 blocks down the street from where we're sitting here, Fred, the president gave an address to the United Nations and received a standing ovation. How do we know about that? It's amazing. We don't know, because every network, not just the cable, every major network covered the 4 hours of testimony about whether or not the Kathleen Wiley letters should have been returned or not returned. It's absurd. The entire world is watching this country shoot ourselves in the foot with a Titan missile.
John?
I take a different opinion, Fred. I think if I hear from Betty Currie and Monica Lewinsky, and I'm convinced that the president did go about like a common criminal in an orchestrated fashion to influence their testimony, to cover up physical pieces of evidence that were incriminating to him, I can't do that. Mickey can't do that. No one can do that. That's a felony. And so if I'm convinced that that's what he did, that I don't think he has the integrity to hold the office, and in terms of being a high crime or misdemeanor, having the integrity to hold the office and having the public trust was one of the grounds that the Founding Fathers did discuss and agreed upon. Even when they tossed out the word maladministration, they tossed it out because it encompassed too much. That is true. They threw it out because it encompassed too much, but they were all in agreement. And if you look at the commentaries from the state ratification process, not the federal one, but from the state ratification conventions, there's broad consensus that an act such as that would constitute a high crime or misdemeanor.
I think you're digging pretty deep if you're trying to go back to the writing of the Constitution and what was said in ratification processes amongst the states that existed at that time. Nowhere in the Constitution does it state that a president can be impeached because political winds